Uber was introduced to Malaysia in January 2014 and Grabcar a few months later in May. Just slightly over 3 years after their introduction, these two applications have revolutionized the public transport industry in Malaysia. They also created economic opportunity for a lot of Malaysians. The last estimate was 60,000 Uber and Grab drivers in 2016, which was heard in the Dewan Rakyat. Today, there could be much more.
Uber and Grabcar operates through their e-hailing application that should be downloaded by the users before they could book a driver. The first step that should be done is to key in your pick-up and drop-off locations to get your estimated fare. Next, Uber and Grabcar will help you in finding the nearest driver around you. Then, the app will tell you the location of the driver and the estimated time for the driver to arrive at your location. And lastly, you could share your ride with your loved one for added safety.
Crimes that has been committed by either Grabcar or Uber driver is considered as huge issues. Previously, we never heard any kind of crimes that has been committed by these people, but now we can see most of the crimes such as rape, robbery and sexual assault are committed by these people. So, do you think that the drivers, either Grabcar or Uber, will be solely liable, or the Grabcar or Uber company will vicariously liable?
Before we discuss deeper regarding this issue, we should know first what is vicarious liability. Basically, vicarious liability refers to a situation where someone is held responsible for the actions or omissions of the other person. The situation of the case is like this. When A committed negligence against B, but C is also liable for the damage and injury suffered by B. This happens because of special relationship between A and C, and one of the examples is between an employer and employee.
In order to prove whether Uber or Grabcar is vicariously liable towards the plaintiff or not, it has to be proved that the contract is of service, not contract for service.
In Malaysia, there is no law regarding the vicarious liability of Uber and Grabcar driver yet. However, there are some ongoing cases that is involved the crime that has been committed by the Grabcar and Uber driver. The first case is involve a pregnant lady. So basically, the pregnant lady was from Mid Valley to Puchong in her Uber ride. However, she didn't notice that an unknown man was sitting in front in the passenger seat, and she has been robbed after that.
The woman who was robbed during her Uber ride to Puchong has suffered a miscarriage just a week after the incident. An emotional Wong Mi Yan, who was a month into her pregnancy, told a press conference on Saturday that she was traumatized by the incident and now she has lost her child.
已经开始觉得很痛，我就去 check 这个还有的。baby 还有在里面，然后过后开始就更加的不舒服，我就去这个 fire doctor 这边，就是昨天 check， 然后他开了那些药，安胎药给我吃，然后过后就是不能，还是不能，到今天早上就这样了，就没有了。
She also said that she would take legal action against the share ride firm for emotional distress and loss as a result of the incident.
我要他们做出赔偿，来弥补我心灵上的损失，心灵的伤害。
Wong had booked Uber ride home and said that she did not notice that another passenger was seated at the front and only realized something was amiss when the driver refused to follow her directions. She was held at knife point and she pleaded to not be harmed as she was pregnant. Police have arrested the driver who is on remand until May 31st.
For the second case, a 29-year-old woman claimed that she has been raped by an Grab driver when she was drunk, and she did not have the courage to fight back because she was drunk at that time.
Grabcar said it had removed the 30-year-old Grabcar driver who had allegedly raped a female passenger. The company's country head Sean Goh said, quote, "We regret that there has been an incident reported on June 11th when a Grabcar driver had allegedly sexually assaulted a passenger. The news is deeply distressing and our priority now is to assist and provide support to the passenger and her family," unquote. He also said he is truly sorry that Grab has let down its users and community. The rape suspect allegedly assaulted the drunken 29-year-old passenger during her ride home near Sri Kembangan early Sunday morning. He is remanded for 6 days to assist police investigation. Meanwhile, after an MCA meeting, Transport Minister Datuk Sri Liao Tiong Lai said ride-hailing service providers would be legalized in Malaysia no matter what.
不会，Uber 跟 Grabcar 都会合法化，但是我们要改善那个制度，我们要看那里的这个问题的根本在哪里，必须要去关注，所以这两件事我们都在跟进。
We are referring to cases in United States. In United States, the question of whether Uber drivers are employees of Uber. Uber stated that the drivers are not employees but are independent contractors, whether an individual is classified as an employee or as an independent contractor depends on whether the person to whom service is rendered has the right to control the manner and means of accomplishing the result desired. The prevailing view is to consider the totality of the circumstances, reflecting upon the nature of the work relationship between the parties and placing emphasis on the control exercised by the employer over the employee's performance of employment duties.
Jane Doe against Uber Technologies Incorporation in the United States District Court, Northern District of California.
In February 2015, in Boston, Massachusetts, Doe and her friends used the Uber app to arrange a car ride after they had gone to dinner and then to a party. Uber driver Abdurrahim Dakiri confirmed that he was on his way and picked up Doe and her friends. After the driver dropped off Doe's friends first, Doe gave him the address of her destination. Dakiri did not take a direct route to Doe's destination but drove more than 15 minutes off route in order to increase his opportunity to sexually assault her. Dakiri parked the car in a remote area and continued to sexually assault Doe until she was able to unlock the car door and run away.
Ang Jiang Liu against Uber Technologies Incorporation in the Superior Court of the State of California.
On December 31st, 2013, at just before 8 p.m., Huan Kuang was walking home in San Francisco with her 2 children, Anthony Liu, who was 5 years old, and Sophia Liu, who was 6 years old. They approached the intersection of Polk Street and Ellis Street. When the light was green for them to walk, they began to cross Polk Street within the crosswalk. As they were in the crosswalk, with the signal green for them to walk, a vehicle driven by defendant Said Muzaffar turned right from Ellis Street and collided with Huan Kuang, Anthony Liu, and Sophia Liu. The collision caused the wrongful death of Sophia Liu and caused serious and significant physical and mental injuries to the other plaintiffs in this action. In these two cases, Uber argues that plaintiffs have not alleged sufficient facts to establish that there is an employment relationship between Uber and the drivers. Uber alleged that the agreement signed between them is not as an employer and employee. Instead, they are just an independent contractor. The drivers generally do not receive a salary but are paid by the ride, and that the drivers supply their own cars and car insurance. The court found Uber is not the employer to the drivers. The drivers is indeed an independent contractor. Thus, Uber will not be vicariously liable for the misconduct of the drivers.
Assalamualaikum, my name is Daniel and I'm 23 years old. I work as a part-time Uber driver. I start to register as an Uber driver through online, whereby they ask for photos of a driving license, vehicle registration and proof of insurance. Uber then performs a background check throughout a third-party company. But all I can say is it's not very difficult to apply to become an Uber driver. I choose to apply to be one because of the flexibility of the work in terms of time. I think Uber should be liable because I have signed an agreement with the company. So for anything I do, Uber should also be responsible for it. Even though I use my own car for offer ride to passengers, Uber is the one who pays my wage, and I will always refer to Uber if anything happens.
Now, first and foremost, we have to understand the nature of these drivers and companies when it comes to e-hailing services. In the general context, people might see that they are employee of the company, but when you look deeper into their relationship, you can see that the relationship between the drivers, the Uber drivers and the Uber company are not employer, but rather the drivers are first and foremost independent contractor. They are not employee of the company. Generally speaking, a company would only be liable for conduct of the employee if first and foremost the person who does the misconduct is an employee, and secondly, if the misconduct was done in the course of the employment. This is what we call the tort of vicarious liability, whereby an employee does a misconduct or wrongful action or omission in the course of employment. Now, when Uber driver transacts or contracts with Uber company, they do not sign employment contract. What they sign is an agreement in capacity as an independent contractor. So that's how Uber can protect themselves against any misconduct by the drivers. Now, with that being said, if the drivers conducted any misconduct in the capacity of as Uber drivers, would it be done in the course of the employment?
In our opinion, the status of Uber and Grabcar drivers is actually under an independent contractor. This is based on the decided cases from other countries. However, we also opined that we should not only put the blame on the driver itself. Instead, the law should take into consideration to put the liability on Uber and Grabcar company as well. This is due to the fact that Grabcar and Uber company are the ones who are responsible on doing the safety checks and also to choose the eligible drivers of Uber and Grabcar. So therefore, we really hope that the law in Malaysia will help the victims in getting the compensation that they really deserve.